Look now at President Trump's antitrust agenda. Joining us in an exclusive interview is Macon Delrahim. He's the former U.S. Assistant Attorney General of the Antitrust Division in the first Trump administration. He's also a partner at Latham & Watkins. And there is so much to talk about as people try to make sense of what's happening here. We obviously have tariffs coming in hot. Well, we'll see, hot or cold, on Wednesday. But I'm curious, before we even get into it, what you're seeing in terms of M&A pipeline, what people are really talking about, because there was this expectation we were going to have a lot of deal volume. The deal volume has not really materialized yet, I think in large part because of the tariff story.
Yeah, thanks for having me. I think what we're seeing is we've never been busier as far as the people contemplating transactions, both strategic and private equity. But people are starting to take a look, you know, the type of exuberance that they had back in November. You know, folks were coming in with ideas of, you know, the first and the second and a three-party market trying to merge because they thought there was going to be some kind of a holiday on antitrust. And I think the signals are being sent by both Chairman Ferguson and Gail Slater at the Justice Department is that, no, the antitrust laws will still be enforced. And in fact, will be enforced pretty vigorously.
Well, that's what I was going to ask. I mean, do you think it's going to be, how enforced do you think they're going to be, and how aggressive do you think some of these agencies are going to be? You even look at an FCC, for example, and, you know, some of the letters they've been sending some of the media companies in the past couple of weeks around DEI programs and wokeism and other things. And I think there's some question mark about whether certain types of deals can be done at all.
You know, there's certainly a handful of transactions being caught up in various regulatory stages. I think what you're going to see is an easier process than, let's say, the last 4 years with respect to transactions that could be fixed. So these are ones where you can have a divestiture or remedy. My friend Jonathan Cantor, you know, took the position that he wasn't going to do any remedies until, you know, there's a handful of them that were imposed on them by courts. But they wanted to challenge, they wanted to litigate, and they had a pretty good track record for the handful of transactions.
What is the impact going to be of what DOGE and Elon Musk are doing on the DOJ and antitrust? And the reason I ask is they're closing effectively field offices and other things and moving some of the functions and the like. That may make it more efficient, but also may make it harder to get some of these things through, or even just to get people's attention?
I think so. So there was this memo from the Deputy Attorney General that went to the division and to all the sections of the Justice Department asking for their input. There's been a lot of panic about some offices being closed and some functions being consolidated. And I think we're in the early stages. I wouldn't count on all the changes occurring. I think it's a listening tour, more or less. But look, there's going to be some reorganization that needs to happen. My favorite one has always been moving the antitrust functions of the FTC into the Justice Department.
Do you think that's in the offing?
I wouldn't be shocked if that's something that happens. I mean, it only makes sense, right? CFPB doesn't need to be in the Fed. It could perfectly fit within the FTC's Consumer Protection Bureau or the Treasury Department. You don't need two federal antitrust agencies. All you need is one. The FTC can do a lot more efficiently. I think, you know, just as mergers have a lot of synergies in the private sector, you can have them in the government.
Maybe it would be good for business from that perspective to not have to worry about two different places coming after you or two different sets of rules that were being laid out.
Well, two different sets of rules, two different legal standards. I mean, I get asked on different transactions where we have to go to boards to say, okay, which agency is going to review this? It's like, I don't know. Yeah. There's only a handful that by statute goes to some of them. But some of them, they get into a wrestling match between the two agencies. And they eat up a lot of the time for the merger review by going there. And then you have a completely different process at the FTC than you have at DOJ. It makes no sense. There's legislation introduced in both the Senate and the House on that.
What do you make of the larger debate that's happened even over the last week or two now in the world that you inhabit, which is the legal world of law firms? And I'm thinking of Paul Weiss and Skadden, which are settling effectively with the administration, and other law firms like Wilmer Hale and Jenner and others that have gone to court and actually won against this administration, and how you personally sort of look at all of this, because I think there's a major question. I was just looking at a letter that was written to by a lot of these professors at Harvard who seem to be, out of sorts about law firms like this effectively settling over some of their programs at their firms.
Look, that's a really hot topic right now for firms and everybody involved around that. There's no question that some firms use their prestige and their brand to actually become a subsidiary of the DNC, and they didn't take on representation of conservative causes and others. Fortunately, that hasn't been our experience at Latham. We did work for conservative causes. And so that's something that is a hot topic that we'll see how it all shakes out.
But what do you think? How do you think it's going to shake out? Because I know there are clients that I've talked to in the past week, even when I was in Japan on vacation, who were suggesting, look, Paul Weiss is settling with the government, Skadden's settling with the government. If you had a case that you had to bring against this government and this administration, and you actually needed to go with the case, not try to settle the case with the government, but you actually needed to bring the case, you would actually not use Paul Weiss in the end. You would not use a Skadden Arps anymore, because clearly they would say they're trying to placate this administration. And if you were a client that needed to fight this administration, that's not where you want to be.
I think everybody has to take a look at the practices internally. I think some of these have been focused on, some of the DEI initiatives. But I think, we will see how it all shakes out over time.
Do you think it was meritless, or do you think that there was cause to go after? You seem to indicate that some of these law firms acted as an arm of the DNC. So that would mean it's not meritless. And you don't just think it's just a witch hunt and retribution train or whatever.
Okay, it's, I think there's, some cause.
The ones that we just were talking about?
Well, let me ask you this, though. I mean, let's put it in this context. So Jones Day has done a lot of work for Republicans, a lot of work for conservatives.
And what was the
okay?
Was
nobody attacked.
Was that yeah?
And nobody went after Jones Day. And one of the reasons why, because
I didn't say why.
The question, though, is whether the administration should be going after private law firms and whether it has a chilling effect, ultimately, on lawyers and their ability and willingness, effectively, to take on difficult cases. Because part of what we've talked about forever is that everybody deserves good and fair representation. Everybody deserves that. Even somebody who we think is completely guilty and terrible deserves that. And if you get into a position where you feel like, if you're a lawyer, that this administration is going to somehow go after your law firm for representing somebody that they don't like, or they don't like the position or the politics of it, that is an issue, no?
Look, everybody deserves that. That's what we all learn in law school. But there was a period where I think a lot of my friends in the Trump administration who couldn't get representation out there 4 years ago. And I think
hold on, can I ask this question?
Joe was saying.
They couldn't get representation because there was a view that that Democratic administrations were going to undermine and upend the business practices of those law firms? Because I had never heard that before, if that's what you're suggesting.
Oh, yeah. I think there's a lot of them, and there were many who wouldn't get hired in some law firms. And these are brilliant lawyers.
No, but what I'm asking is they wouldn't get hired because there was a view that the administration was going to somehow attack the business practice of that law firm, or was it that their views didn't match, for whatever reason, the views of the law firm? If you say that they're more liberally oriented,
more the latter, I'd say.
Okay, but that's different. That's a fundamental difference.
And also firm clients. There were some
absolutely
that demanded certain things.
Right.
But again, I think everybody deserves representation and conservative causes.
Do you think
as well.
the firms that are settling are just at this point saying I'm settling without admitting guilt? I mean, that's what we're implying here, is that there was no, there's no there. There's no, where there's smoke, there's usually fire. I'm sure that there's a good cause to go after some of them.
I don't know. I just don't know about the facts.
But do you think they're just saying, okay, these guys are coming after me, I'm going to settle so that I don't get in more trouble with the Trump administration?
I think some are taking a deep look at their practices, whether it has been their hiring or their representation, and taking a look at that.